Welcome back once again to another episode of Miami Market Update, where we discuss everything real estate from the client's perspective. Today we're going to be discussing estate planning, wills, trusts, and really the thing that most people don't want to think about. The exciting part is once you buy a home, you become a homeowner, you're excited, you figure mission complete, but we don't want to think about the probate, the estate planning aspect of it, because that means that we're talking about the demise of someone that owns a property, but it's a very important topic that you need to wrap your mind around through the home buying process and after it, so that way you protect your assets. Today we have with us Kymberlee Smith. She's an attorney. She'll be able to discuss all the ins and outs of probate, wills, trusts, even ladybird deeds, life estate, things of that nature. So I'll let her introduce herself and give a little background on areas of expertise and what she could bring to the table for you. Kimberly.
Good morning, everybody. Thank you, James, for having me. As he mentioned, my name is Kymberlee Smith. I am a solo practitioner. I have my own firm, and my main practice areas are real property, probate. I also have a title company and estate planning and some municipal government matters as well. And happy to be here to talk with you about estate planning, some of the things, like you said, we don't want to talk about but should.
And I appreciate you taking out the time to come, because as an attorney, I know your time is valuable, and I truly say time is money. And a lot of people, they have these questions, but they're afraid to ask them, because a lot of time people are afraid to either discuss, death situations or letting people know what they don't know. But in my career, I realized that, once they buy the property, everything's moving smoothly. But the longer I've been in the industry, I'm getting more questions about how do I handle this? A family member passed away, now they need to face these situations. We're going to talk about, first and foremost, after they buy the property, they settle into it. What do you think they should have in place to protect the asset, to make sure that it can transition to the family members, or how they intend for it to be dispersed after they pass away? What do you think need to be in place, or recommend need to be in place for that to happen early on?
So for the property itself, I think most commonly people think about a will. Wills are obviously a proper tool to ensure that your property transfers to who you would like it to go to. Everyone says that if you don't have a plan, the state has one for you. The statute literally lines out next of kin. So if you don't have a person or people named, the state will go by next of kin, and those people will be the ones to inherit your property. If most times older people or parents, no matter the age, typically want to make sure that their children get the property that they've purchased. I think, I'll say back in the day, but not really. I'm speaking from my perspective. When you have grandparents who've purchased properties for, I think my grandparents purchased their property in Carroll City, what is now Miami Gardens, for like $17,000 when they did. And I mean, now it's close to $500,000. So when you have properties, you want to use a will. You can use a ladybird deed. You mentioned that. It doesn't work for everybody, but when you do a will, you still have to go through probate, which is the court process where a judge will ultimately confirm the transfer from your estate to who you'd like it to go to. A ladybird deed does allow you to avoid probate. It doesn't work for everybody, but where it works, it's really nice because it does allow people to keep control of their property, and only upon their passing does it go to whoever it is that they've designated. Okay. Some people will use a joint tenants with rights of survivorship deed. It doesn't always work the way they expect, because it literally means that you're now a co-owner with somebody else. And I don't think most people intend to co-own a property with who they may want to leave it to. They just want to secure that that person has it. Right.
Now, you just spit out a lot of information, and I know, me not being a lawyer, some of that stuff is overwhelming to me. So let's take it in smaller bites. Okay. So what if somebody put a will together, they fill it out how they want things to be dispersed, and they tuck it away in the Bible in their house and just put it on the shelf? Is that sufficient?
If it's done properly.
No, they just write it out and they say, okay, this is how I want things to be dispersed, and they just took it away.
It needs witnesses.
Okay.
It needs their signature. And to keep it easy, it would need a self-proving affidavit, which is kind of a last provision on most wills where you're kind of confirming that it's you. The witnesses have confirmed that you were you, and, it's formalized. So it needs to have all the pieces that the statute requires. So if you just write it down and you stick it somewhere, it can be helpful in a probate, but it would not be considered a full proper will with all of the requirements from the state. So
you're saying even with the will, you still have to go through a probate process to get the property transferred to whoever the beneficiary of the property is, correct?
Correct.
Okay.
Because when you pass, your assets remain in your estate, and to get them out of the estate to the people that you want them to go through or go to, you have to go through the court process to confirm your assets, transfer them to who you want them to go to, and also to pay off any debts that may be outstanding from your estate.
And you also mentioned a ladybird deed. Is there another name for a ladybird deed, or is it like a life estate? Or?
I think the proper term may be an enhanced life estate deed. So to be specific, what a ladybird deed allows you to do is, as we mentioned, you own your property in your lifetime and in your death through your estate. A ladybird deed allows you to separate or bifurcate, the nice fancy word, for that ownership. So you would transfer it from yourself to yourself, basically for your life. And then after you pass, it goes to the people, they're called remaindermen, that you designate after that.
Okay, that's interesting. So you say with that type of estate being set up, probate isn't necessary, at least for that portion of it, if there's ladybird deed set up with remaindermen attached to it?
Correct, and that's for real property. So yes, if it's set up properly through an enhanced life estate deed, also known as a ladybird deed, you don't need to go through probate for that property.
So how do they get the property transferred to them at that point if they're listed?
If there's a ladybird deed?
Yes.
So, it's said that, at the point that the life estate tenant closes their eyes, it immediately becomes owned by those remaindermen, but they do need to take a death certificate to the clerk to be recorded, so that there's an explanation of how the property is now in that person's name and not in the previous owner's name. And if there is an outstanding mortgage, the state would require like a transfer tax. So you'd pay taxes on the balance of that mortgage in that transfer.
I'm glad you brought up the mortgage aspect of it, because in my practice, in my experiences, I've been coming across more often than not now, family members who've acquired a property or trying to get the property transferred over to them, and there was an existing mortgage in place. What do they need to be aware of if a person passes and there's a mortgage in place and they have to go through probate? What's some of the hurdles they need to clear in order to move forward?
So ultimately, they would need to get their own mortgage to satisfy the existing mortgage. The property may be legally transferred to them or being transferred to them as the probate, is open and closes. But the mortgage will always be in the name of the person who signed the note and the mortgage. So the note is the contract to repay the bank, and the mortgage is the lien against the property until that lien or until that note has been fully satisfied, right? And so if you inherit property and there's a current mortgage, ultimately you're going to have to get your own mortgage. But in between, you can, before the person passes, they can make you like a designated or authorized speaker, on their account, or a contact person on the account. But if that doesn't happen, you would need to have a formal administration, which is kind of the long version of a probate, wherein you're designated as a personal representative. That is the only person that would be authorized to do business on behalf of the estate. They can reach out to that lender, provide the letters of administration and appointment of personal representative to the lender so that they can talk to them. If you are not a designated person for that estate, they will not share information. A lot of people hit a wall with that because they're trying to get information. You can be clever. Maybe you have a statement, or maybe you have the information from your parent or, whoever it is, and you may be able to get it. But usually you're not going to talk to a person who's going to share it with you without having provided them through fax or email.
Right,
with
authorization.
Correct.
Okay, so how aggressive can a lender become once a person passes and there's an existing mortgage in that person's name tied to that real estate? Is there a certain time frame before the bank finds out about it? What the family say, well, I'm just going to keep paying a mortgage payment for the next 5 years, or I'm just going to keep things moving the way it was?
So there are spaces where you can continue to make payments. I mean, everybody, knows that paying is kind of what keeps the dragon quiet.
Right.
But ultimately, it usually comes out somehow, whether the tax collector, on the property appraiser's office, it gets updated. Somehow it gets out. Once that happens, the bank is going to start communicating with somebody, expecting a personal representative to reach out to talk to. Usually the time frame most people consider is about 3 months of no payments. They really kick up. But if you're going through probate, you can communicate that to them. Some are a little lenient and will give you time, but you do need to be actively communicating with them. They need to see a case number. They need to see an appointment of a PR. They need something to prove that you're making progress. Otherwise, they just move through. And probate doesn't stop the foreclosure process, but the attorney representing the bank may give you some time or not be so aggressive with the process if you are actively communicating. If you have a reverse mortgage, there's a time frame allotted, which I think is typically 12 months, that you have to get that process, the probate process, completed, and then they will start foreclosure if the matters with them have not been resolved.
Okay. Since you brought up the fact about the mortgage, once the mortgage company becomes aggressive and say, look, payment is delinquent more than 3 months, time is ticking, and no one is able to get a new mortgage, and they start contemplating selling the property, what hurdles are there if they want to sell the property? Probate is not complete yet, but the time keeps ticking and getting closer to an actual sales date. What are the options available to families that may be facing that situation where, okay, the bank say they want their money, no one's going to be able to refinance the property or purchase it, we need to sell it. So what type of, time frame are they looking at that point?
So, one of the things that helps the time frame is cooperation. I'll be honest, in real life, many times time is lost because the families are not getting along. If everybody's on the same page, the estimation of when you might be able to get the property sold may be a few months. The probate may not be closed, but you can get the appointment of PR if all of the siblings sign the waivers, not contesting, and everything is smooth. You would then get the property listed, get it under contract, and then ask the judge for permission to sell that property. The property would be sold, a court-designated account for the estate would be established and opened, and then the money would go into that account. The bank would be repaid, and then the money that is to be distributed amongst the beneficiaries or the heirs would stay in that account until the process is complete and the judge gives permission. But you at least don't lose the house.
Right.
So that would be a perfect storm to save the house. Everybody can ensure that they'll still get their share.
What I've seen with some clients have come to me is, they're delayed and procrastinated for so long, and now they're up against a hard deadline, and then they've come to me after they've signed a contract saying that I got a cash offer, I want to go ahead and sell, and when I run the numbers, I'm seeing they're leaving hundreds of thousands of dollars on the table because, in my experience, a lot of these cash investors, they have a set matrix where they won't pay more than 70% of market value. And I know one of their angles is, you don't have to pay a commission or fees. Commission and fees could run anywhere from 3% to 7% of the sales price. but we're talking about they're leaving 30% on the table. I think most of that comes from the fact that so much time has been wasted.
Yep.
What do you recommend be done early on to prevent being painted into a corner to prevent having to make such a rash decision?
I mean, I think, the obvious answer is to get an attorney. If you're a realtor or broker, if you trust that person and they come to you and say, James, what do I do? Oftentimes you may call me or somebody else that you think can assist them. They need to get professional assistance because people will, take advantage of that. Best case scenario, you have a plan, you have an estate plan from the loved one that passed away, but most times you just need to go find an attorney who can assist you so that they can make sense of it, help you maybe negotiate a contract if your realtor's not doing it so that you're getting a fair market value. You may need to get a payoff from the lender to confirm the outstanding amount owed on the property to make sure that your sale price is high enough to cover that and clear you, funds if you need it, obviously, or want it, or there are other things that need to be paid off. But really and truly, they need to seek an attorney immediately because what you said is correct. People wait. It's either they don't want to pay for it, they don't see any benefit to having to do it right away because it can be a process. Right. But for most people, what triggers them is the property taxes trigger. Because once that person passes away, that homestead, if it is a homesteaded property, falls off. Right. And those taxes jump. And so it's either a panic of, I can't afford this, how can I homestead it for myself because I'm already living here? Right. Or all of a sudden we've not done anything and now the bank is calling and this person comes in with cash. Right. And there's all kinds of nuances that, if you don't know any better, there could be liens, there could be anything going on that you may or may not have agreed to pay for, right? So what you think you're getting, you're not really going to get. Right. Or the process has hiccups and now you need an attorney to help stave off a foreclosure and help you with a probate. So it's doubly expensive if that happens because you need to kind of try to keep both doors open to give you time to do what you need to do.
Let me ask you this. I know as an attorney, your main focus is to interpret and explain the terms of any legal document to the client. So if someone is presented with a cash offer that comes out of nowhere, what would you recommend? Do you think they need to talk to a realtor to figure out if the value is
For sure, because most times, as you know, cash offers are less than what the market value is. Correct. So they absolutely need to speak to a realtor. I think people need to be informed. This is South Florida. Right. And we are, I think, the fraud capital of the country. Yeah. So there's so many scams. And you don't know when you have time to move out. I mean, nobody's explaining things. They're rushing you so that you just sign, and you have no idea what's happening. So they need to consult a realtor to be able to get a true market value of the property. And they need an attorney to help them figure out what to do and make it make sense so that it's efficient. Okay.
You brought up on reverse mortgages before. I've had many clients come to me after they lost the property that they inherited saying, well, it was a reverse mortgage. Don't the bank own the property anyway when it's a reverse mortgage? Or what options do heirs or beneficiaries to that real property have if there's a reverse mortgage on the property? Do they just throw their hands in the air and say, well, call the bank and tell them pick it up? Or do they have an opportunity to sell the property independently to satisfy the bank and possibly even profit from the sale of the property?
There's definitely an opportunity, right? So one thing I'll say about the reverse mortgages is a lot of people hate them. And I think it's because they don't know that it exists. Right. Right. And when they figure it out, because the interests are adverse, the bank is like a demon to them in terms of trying to figure out now how to correct this situation. The reverse mortgages are great for people who need it, right? Most kids are not going to fund their parents. Right. And if the parents need additional income and they have that equity there,
They're going to tap into
that's what you need to use.
Right.
I think best case, you tell your kids that it's there. Best case, you know how much time you need to deal with the probate. If you need to sell it, you can sell it. The bank doesn't own it. What they have is the equity, right? And if the property has increased in value, you may have enough equity to kind of cover what you've taken out to use. So you can sell it. You can get your own mortgage to pay off the balance that was, taken out to use and pay the bank back their money, and then you keep the property. So they have options.
Okay.
But definitely they should speak to their lender or their mortgage broker about the reverse mortgages. They are different, and you need to know what you're doing when you are going to get one or trying to resolve a property that has one.
Yeah. I found a lot of people are reluctant to have these things put in place because they look at the cost, it costs too much. And, some people may be financially prohibited for them to do certain things, but always say not what it costs you to do something, what will it cost you not to do something. So what would you recommend the most basic things somebody should do once they own a property? I know when you're young, you don't think about wills and who's going to inherit the property, but what do you think should be in place? I always tell people this. When you're buying a home, obtaining it becomes the easy part. Maintaining it for that lifetime becomes the hard part. What do you recommend they should do, and how early they should do it after they become a homeowner, to put things in place and safeguards so they don't have to worry about that later on?
It's never too soon. I mean, I know that means different things for different people. It's never too soon to do estate planning. The typical estate planning package looks like a will. And a will, if you have a ladybird deed, that deed would be used for the real property. And I'm assuming, for this discussion, there's a primary home only. If you have assets in the bank or retirement accounts or insurance, you would add your beneficiaries to those accounts. You would get a healthcare surrogate, a living will, and you would get a power of attorney. And so, you can get a trust. Not everybody needs a trust, but it definitely is cheaper to do it in advance, because if you wait, it's not only the money, but the drama that comes with somebody not having their affairs in order and a family who's at odds. It almost is never what the person wanted. Right. They assume everybody will behave. They assume that everybody loves each other, but oftentimes they are the person that is helping everybody behave. Right. When they are no longer in the equation, you get different personalities. It's like kids with a parent, and once the parent goes away, all hell breaks loose. Right. So definitely, it may cost a couple, maybe a few $1,000s to get your estate planning in order. But, if it's an issue, I know most lawyers would choke me through the microphone. But if somebody says, hey, can you let me have a payment arrangement? If that's where you are and you trust the person that you're dealing with, they may very well be okay with that. Right. But at the end of the day, the cost that the family incurs afterwards can be quite high, trying to get everything untangled. And so usually there's one or two people that are, the executor or executrix, or really just a personal representative that's handling things. Oftentimes it's the same person throughout. Same people in the will, same people in the healthcare surrogate, same people, which, that consistency helps. Right.
And you say you do title work too, you're a closing agent. All right, what if someone, because I've had clients come to me, a lot of this stuff comes from, the questions I have come from experience I've had as a realtor, and clients have come to me. One of these investors they saw on TV, they called and they say, look, the guys say they'll give me $10,000 up front. They gave it to me. I signed a quitclaim deed, but now I'm just waiting to sell the property so I can get the rest of my proceeds. What's the danger in signing a quitclaim deed, and what do you recommend in those type of situations?
Well, first, the question is, even if you have a mortgage. If you have a mortgage, you should not be signing a quitclaim deed because there's a mortgage. Right. As a title attorney, I always tell people title on property is similar to, at least for me, a credit report for a person. Whatever's in the public record is kind of in chronological order of what has happened with that property, right? So if you sell over a property or sign over a quitclaim deed, or somebody signs one to give it to you, you have a property that could perhaps have tons of liens. And liens are title issues are things that show up in the public record that mean that other people have an interest in your property. It's not only yours. So it's important to do title searches, lien searches, even surveys, wherever, title is involved and there's a lender. If you have a lender, you have no choice but to get title insurance, which is the ultimate goal of a title attorney, to make sure that the property is clean so you can get title insurance, which means that if anybody else tries to stake a claim to your property, you're insured. But your due diligence has to have been done to make sure that. So the quitclaim deed is dangerous and it's not to be trusted. Yeah,
because I've seen a lot of people that went ahead and signed deals that say, I'll close you in 24 hours. I know in real estate, speed kills in these situations because you don't know what's under the table. Right. So what do you recommend when they are presented with an incredible cash, the most cash they probably ever seen in their life being offered to them, and they say, look, he's going to close in 3 days.
Call a lawyer. Call a lawyer. Call an attorney who deals with real estate, who deals with title, or go to your realtor and let them take you to an attorney that deals with real property or title. Because honestly, if it looks that good, something is wrong. I can't say that this is South Florida enough. It is a flag with flags attached to the flag, because you just don't know. You don't know what you're getting or what you're giving, and you don't know what can come back. Title issues can come back. And so people will give you quick money, but if there are things that haven't been resolved, your name may still have a lien against it or a judgment. Those things don't just go away because the property went away. They stay. And so those things have to be found and resolved so that they do properly go away.
I know this conversation could keep on for 2 or 3 hours if we let it, but and for the sake of time, if someone does have more questions for you or just want more information about what their rights are, what they should be doing, how can they contact you? My office number is 954-500-5277. My email is info@kcsmithlaw.com. And I appreciate you know more than you're letting on this morning. But in all honesty, you're an honest person. You're a good person. And so for people who are working with you, they should be comfortable that they have the right person helping them. That is so not the case here. Not every realtor is a good person, has integrity. And so it's a scary place to do real estate business here. So good attorneys, good realtors or brokers are definitely, those are the people whose hands you need to be in. And can you confirm that's not a paid endorsement? Not a paid endorsement at all. Again, we thank you once again for joining us. We're trying to bring this to you, this information to you as frequently as possible. We like to come from the perspective of the client. When you're sitting at the table and you have all these overwhelming questions, it can be a daunting place. So what we try to do is create a space in a forum where we try to bring as many questions as possible that answers relevant questions to the novice that's in the real estate industry. Think about buying, selling, first-time home buyers, first-time seller, or even if you're selling a property or buying a property for your second or third time. It's always good to put that team together. And we want to bring you more topics. Hopefully you'll send us a message so we could increase the topics that we bring to you. Once again. Can I stick one more thing in? Yes. Always. When you have a probate open, there are people who troll the records. They can see that you have a probate open. You'll get an overwhelming amount sometimes of mailings asking for your property or offering your, making offers for your property. Again, reach out to your realtor, reach out to an attorney and talk to them about that. People wonder, how do they know? They can see it in the public record, but it doesn't always mean that it's legit. So again, Yeah, because I'm probate certified too, and there is software that automatically goes in and creates mailing lists and things of that nature once someone does file for that. So that's a good point you brought up. So yeah, don't become overwhelmed in the process. Reach out and get as much information as you can so you can make logical decision. Again, we thank you once again for joining us. This wraps up this edition of Miami Market Update. Thank you. Have a wonderful